The case pertaining to the unauthorized use of the T brand trademarks Imona and Canure device owned by A.F. Jones, a subsidiary of the Capital Maharaja organization, was taken up before Colombo Fort Magistrate Thilina Gambage yesterday. Today, the counsel for the plaintiff pointed out confusing elements in legal facts mentioned by the defense counsel to the media upon exiting court yesterday.
The Maharaja organization, who are the plaintiffs in the case that was heard today, have requested an injunction through a case being heard at the Colombo Commercial High Court. Since the search warrant and summons were obtained from court without informing court of this fact, we submitted on behalf of Vintage Tea Company that the summons be reissued. The magistrate accepted our premise and noted that if there were objections, the Maharaja organization could make written submissions within a month. At the same time, the magistrate allowed the directors of the Vintage Tea Company, who appeared in court today, to leave court after they signed personal bonds.
I
wish to correct certain inaccurate statements that have been made by the lawyers for the defense in respect to the Capital Maharaja case which has came up in court yesterday. Now this case has been filed by Capital Maharaja organization against Vintage Teas and its board of directors Jayamal Rajapaksa, Palita Karunanayaka and Vinod Vijayatunga. Now the complaint that has been made by us to court is that Vintage Teas deliberately infringed the trademark rights of Capital Maharaja organization and its subsidiary A.F. Jones Tea, who are responsible for the export of the tea under the trademark and brand names Canary Device and Imona. Now in the complaint that we have made before court, a very important fact has been set out, that the three directors, Rajapaksa, Karunanayaka and Vijayatunga, were all past employees of Capital Maharaja organization and A.F. Jones, and they have been fully aware that Canary Device and Imona trademarks have been registered with Capital Maharaja organization. The defense lawyers have been making certain statements to Sirasa News channels plus certain other news channels, stating that we had obtained a search warrant and summons on the accused by suppressing and misrepresenting material facts to court. Now this is a completely false statement, an inaccurate statement, because all material facts that were required to be disclosed to court have been disclosed to court, and all facts have been, and evidence was thoroughly evaluated by court, and the court had gone into the extent of taking oral evidence as well, apart from the papers filed in court, and the court thereafter reserved its order and went through matters further and felt satisfied that there was more than fair reason to issue a search warrant and summons on the accused. Now the matter before the magistrate court is a very simple matter. We are the registered owners of the trademark Canary Device and Imona. As a registered owner, all rights accrue to the registered owner to use the mark, to assign the mark, to give license contracts under the mark. All those rights are accrued to the registered owner. Canary Device and Imona is a mark that has been actively used by Capital Maharaja organization and its subsidiary which exports the tea, A.F. Jones Limited. We have not under any circumstances granted any permission to Vintage Tea or its directors to use our mark. Also the defense has mentioned to the media that their objection was accepted, and that we had to, if we had something to say or reply, then we were given the next court date. Now that is completely inaccurate. It is not that their court has accepted their objection and think their objection is correct. The court is just hearing the objection and court is waiting for our response to finally decide on it. And I mean, I can tell you very clearly that Capital Maharaja organization is well within its rights and has conformed to all required standards under law when filing this case and making applications before court. And also the accused were not released only on personal bail. Yesterday, the court released them on personal bail because they were not ready to furnish the other bail conditions that was required and ordered by court. They were the directors of Vintage Teas were asked to place 2 sureties each in court who happened to be their closest family members. So now that is the correct order that was made by court, and not merely that Vintage Teas directors were released on a personal bond. They have to, on the next date when the case comes up in court on November 24th, they have to place the sureties in court.